So this is the first of our Let's Talk About Trust talks. And Brian, I'm going to be interviewing you, looking back at the past. And in the next one, you're going to be interviewing me, and we're going to be looking at the future. So can you tell us, how did you come to specialise in private client work?
Oh, Emily, I mean, it's the usual combination of accident and good fortune. The accident was I'd taken a lectureship at the LSE when I left university, where they got me teaching land law and trusts. And the good fortune is that that enabled me to go to the bar with the princely salary I was receiving from the LSE. And I did a land law pupillage and a trust pupillage, and the trust pupillage was the second one. And it was with Robert Walker, and it gelled. And I found myself practicing in the area in which I'd actually been teaching, and that gelled too, and I absolutely loved every moment of it.
Being Robert Walker's pupil must be really interesting.
No, it was absolutely fascinating, and I learned an awful lot from him. And I'd like to think that many of the things that he taught me, I still put into practice today. In an almost sort of obsessive fascination with precision in drafting and also in expression when it comes to written work, which was a real hallmark of the way in which he practiced. As it happens, he was able to bring such precision to bear using a dictating machine. I have to use a more laborious process. But no, he was an inspirational teacher and a very good colleague and friend, as it turned out.
Yes, and did you have any other pupil masters?
Well, my first pupil master in land law was Nick Patton. He was the land law pupil master, a different set.
Distinguished set of pupil masters.
Yeah, and he went on to become a Court of Appeal judge. They were both fantastic pupil masters, great people, and they became very good friends.
Through you?
Oh, no. No. I'm not sure they were ever very good friends themselves, though that's not in any way casting aspersions. No. They were very good friends to me. And I became very good friends with them at the time. Yeah.
So over the years, you must have seen some really substantial changes in private client practice.
I think so. You know, when I first came to the bar, private client was regarded as it were, the Rolls Royce of chancery practice, and rightly or wrongly, and it had been many of the most distinguished practitioners and many of the most distinguished and most respected judges were private client practitioners, and the chancery bench had a whole series of specialist private client judges. And they obviously could turn their hands to other things, but they were very noted for their expertise. And other chancery judges would very willingly seek out private client cases because they enjoyed them, they thought it was interesting, they thought it was the sort of work that they wanted to be somehow associated with. Why that was, I couldn't really tell you. I think part of it may have been snobbery, the notion that private client was associated with landed estates, and that made it rather interesting for people to have an association with it. But whatever the reason, it was very, very fashionable in those days. These days, it's quite different, as you know.
Yeah. And do you think that they enjoyed being able to sort of have a role in policy? For example, is it good for young people to have too much money too soon? Is it permissible to help avoid taxes?
Yeah, they certainly had views on those things, certainly so far as regards young people. I mean, very often they'd obviously be thinking about their own children or nephews, nieces, or children of friends. And in the early days, certainly was the case that there was a certain reluctance to postpone vesting for the benefit of children too far. It's not like today where you can put a 125-year perpetuity period in on the basis.
Yeah.
It's not going to vest in anyone ever,
Yeah, but they never like cutting people down to life interest.
No, they saw the point that it was undesirable for property to vest in such a way as to crystallize a capital gains tax charge, which was the bugbear for a long period. And then it became possible to hold over as against that possibility, and then it ceased to be possible to hold over again. But so far as regards tax, and then of course in the early years, even before Ramsey and after Ramsey, when it came to variations, judges always thought tax avoidance was a jolly good thing.
And what about the composition of the bench these days?
That's absolutely, Emily. I mean, that's the other side of the coin. You look at the Chancery bench these days; it's got the composition of fantastic practitioners, obviously, but there's not a single private client judge. Everything has changed. The last private client judge was probably Nick Warren. Whether there'll ever be another one again, one wonders, because it's been the policy of chancellors, probably since Etherton, to move private client business across to masters. They do variations these days, which judges used to do.
And what about economic circumstances? Do you think different governments and things have influenced private client work?
I don't think that they have directly influenced. I mean, indirectly, they may have affected the composition of the work. Post Mrs. Thatcher, there's new money, and new money has came to eclipse old money in terms of the size of the trusts that you were dealing with, and perhaps the objectives with which trusts were being set up, and the objectives which as it were, the variation and the direction of the interests under the trusts were designed to achieve. So that's one indirect effect. The other indirect effect, I suppose, is that governments have had aspirations as regards the taxation of trusts, and they've in their different approaches to the taxation of trusts, they've probably made private client work a good deal less interesting than it was in earlier days, because as you know, certainly the taxation of trusts in the UK now, it's essentially transparent. It's not very interesting at all.
No. And what about technology and things? How have you seen that change over the years?
Well, look, I mean, the world has changed completely, hasn't it? I mean, I suppose the two major developments that I've seen in my practical life is first STEP, which has been an astonishing organisation, growing from very small beginnings to what it is now. Worldwide, absolutely. And the education that it provides to people, and the resources and the know-how, absolutely fantastic, wonderful thing. And corresponding to that, on perhaps a slightly more informal basis, online search engines. I mean, it's revolutionized practice. And also, I suppose, the availability of precedents online means that perhaps some of the know-how that individual practitioners used to be able to peddle is no longer required, or at least no longer cherished in the same way as it was.
And last question, what's the most unusual piece of work you've done?
Well, it's a good job that you gave me notice of that question, because I can answer it. The most unusual piece of work that I've done is that I was when I was a senior junior. I was approached by the London Rubber Company, who were the then owners of Durex, who had a particular problem. And the problem was that Richard Branson and the Virgin brand were attempting to enter the market over which they had total domination. And they were seeking to prevent this. And you may ask, well, what does that have to do with me? Well, the answer is that one of the pitch of Virgin was that a percentage of the profits from their condom sales were going to go to charity.
Yeah.
And this was a pitch on the side of the box. And the London Rubber Company was skeptical in relation to this pitch. And it actually commissioned me to settle a letter to Virgin to put them to proof as to what their actual intentions were. Well, to cut a long story short, the net result was a 9-month delay in the marketing of Virgin condoms. And I only imagine, I speculate as to this, that the children born as a result are probably approaching the age of 30 now. And it's all down to me.
Well, thank you very much, Brian.
Okay.